Hello friends, today exercise number 5 on income tax and land acquisition. I will dictate with a speed of 100 WPM. Okay, I will start my dictation after 5 seconds. By way of response to the so cause notice regarding the penalty of its reply dated 22/3/2006, the SSC claimed that all the details given in the return were correct. There was no concealment of income, nor were any inaccurate particulars of such income furnished. It was pointed out that the disallowance made by the assessing authority in the assessment order under section 143(3) of the Act were solely on account of different views taken on the same set of facts, and therefore they could at the most be termed as difference of opinion, but nothing to do with the concealment of income or furnishing of inaccurate particulars of such income. It was claimed that mere disallowance of the claim in the assessment proceedings could not be the sole basis for the levying penalty under section 271(1)(c) of the Act. It was submitted specifically that it was an investment company, and in its own case for assessment year 2000, 2001, the commissioner had deleted the disallowance of interest made by the assessment officer, and the tribunal has also confirmed the stand of the commissioner for that year, and therefore it was on the basis of this that the expenditure was claimed. It was further submitted that making a claim which is rejected would not make the assessee company liable under section 271(1) of the Act. Sri Bhattacharya, learned additional Solicitor General, submits that Commissioner, the Tribunal, as well as the High Court have ignored the positive language of Section 271(1) of the Act. He pointed out that the claim of the interest expenditure was totally without legal basis and was made with the mala fide intentions. It was further pointed out that the claim made for the interest expenditure was not accepted by the assessing authority nor by the commissioner, and therefore it was obvious that the claim for the interest expenditure did not have any basis. He further pointed out that the contention about the earlier claims being finalized was also not correct, as the appeal was pending before the High Court against the order of the tribunal for the year 2000 2021. According to him, even otherwise, the expenditure on interest could not have been claimed in law, as under section 36(1) of the Act only the amount of interest paid in respect of capital borrowed for the purpose of the business or profession could have been claimed, and it was clear that the interest in the present case was not in respect of the capital borrowed. Our attention was also invited to section 14 of the Act, which provides that no deduction could be allowed in respect of the expenditure incurred by the assessee in relation to income which does not form part of the total income under this Act. The learned ASG also invited our attention to provision of section 1033 to show that the income arising from the transfer of a capital asset could not be reckoned as an income which can form the part of the total income. The petitioners contended that the findings of this court in the judgment and order dated 10/5/1996 regarding the element of compensation are ex facie incorrect and said judgment and order is liable to be reviewed. It was urged that the increased FAR mentioned in the order is illusory and that there were restrictions on the permitted height of construction and many of the owners of freehold land had not been able to use the increased FAR. They contended that if any land is required for the purpose of development or for any other purpose, DDA should resort to compulsory acquisition under Section 15 of the Delhi Development Act 1957. It was contended that no land can be taken over or required to be surrendered without compulsory acquisition under Section 15 of the Delhi Development Act 1957 and payment of market value as compensation. It was further contended that the mere fact that this court did not want the government to undertake the time consuming process of acquisition under Section 15 of the Delhi Development Act would not in any way detract from the rule of law, which requires the landowners of Delhi industries to be treated as par with owners of land in other parts of the country which are acquired for the purpose of urban development. It was submitted that Section 15 deals with compulsory acquisition of land where the land is required for the purpose of development or any other purpose under the DD Act Section 55 of the said Act dealt with modification of the master plan or zonal development plan in certain cases. The said section provided that where any land is required by the master plan or a zonal development plan to be kept as an open space or unbuilt upon is designated in any such plan as subject to compulsory acquisition, then if at the expiration of 10 years from the date of operation of the plan under Section 11 or where such land has been so required or designated by any enforcement of such plan from the date of operation of such amendment, the land is not compulsorily acquired. The owner of the land may serve notice on the government requiring his interest in the land to be so acquired, and if the government fails to acquire the land within a period of 6 months from the date of said notice, the master plan or the zonal development plan shall have effect. The learned amicus curiae pointed out that despite the fact that the master plan for Delhi was published as early as 1990, these large and heavy industries did not take steps to shift their premises out of Delhi, and these industries have been causing severe pollution for a long period, thereby violating the master plan as well as damaging the environment. And it was at this juncture that this court had passed the order and directed all these industries to be relocated outside Delhi and issued categorical directions regarding surrender of proportions of the land. Stop.